Today, the Georgia Supreme Court erased the order that denied Hannah Payne a new trial. The reason, the prosecutor who wrote the state's brief used artificial intelligence to generate legal citations, and the cases she cited don't exist. That's not commentary. That's what the court's opinion says, and I'm going to walk you through every word of it. If you don't know me, I'm Drew Breasy. My real name is Andrew Baxter. I'm a retired police commander with 29 years in law enforcement. A few weeks ago, I sat inside that very courtroom and I watched 5 justices question this conviction. And I made a video explaining what happened, and I'll link it above, because today the court answered. Now, my co-host John is an active 911 dispatcher. He's a certified crisis negotiator, and we've been covering the Hannah Payne case on this channel because it sits right in the middle of what we do, analyzing what happens from the first 911 call to the courtroom. In this case, it's taken so many twists and turns, neither of us really expected this. Now, I'm not an attorney. Nothing I say here is legal advice, but I can read a court opinion. I can explain what it says in words that make sense to the best of my abilities and limitations. But there are 3 things that you need to understand from this ruling. Number 1, what did the Supreme Court actually decide? Number 2, what does vacated mean, and is it a win for Hannah? And number 3, simply what happens next? If you're just joining us, in 2019, Hannah Payne witnessed a traffic accident in Clayton County, Georgia. The driver, Kenneth Herring, left the scene. Hannah followed him. She called 911 and eventually stopped his vehicle. And then a confrontation happened while she was on the phone with 911. Mr. Herring was shot and eventually died from his wounds. Hannah said that it was self-defense and that he pulled the trigger on her gun. In December of 2023, a jury found her guilty of malice murder, felony murder, aggravated assault, false imprisonment, and weapons charges. She was sentenced to life in prison with the possibility of parole. But she has to serve 43 years before she's even eligible. She was 21, 22 at the time. Her new attorney, an appellate attorney, Andrew Fleischman, filed an appeal arguing that her trial lawyer made 2 critical mistakes, that he never asked the judge to instruct the jury on 2 possible defenses, one being citizen's arrest, and 2, the defense of others. The argument is that without those instructions, the jury had no legal path to find Hannah not guilty, even if they believed her version of events. She was trapped. On March 18th, the Georgia Supreme Court heard oral arguments. That's the hearing I attended. And during that hearing, something unexpected happened. One of the justices noticed that the court order denying Hannah a new trial contained legal citations to cases that don't exist. That's where the ruling we're discussing today picks up. The Supreme Court vacated the trial court's denial of Hannah's motion for a new trial. Let me explain what that means, because the word vacated sounds dramatic, but it has a very specific legal meaning. When a higher court vacates a lower court's order, it's saying we're erasing this decision. It no longer stands. Not because we're saying that the lower court got the answer wrong, but because there's a problem with how they got to the answer. You can think of it like a teacher grading a math test. The student might have gotten the final answer correct, but when the teacher starts looking at the work and sees that some odd formulas were used, the teacher's not going to give them credit. The test is going to get thrown out. The student has to take the test again. That's what vacated means. So what was the problem? Let me walk you through it because it's bigger than what you might have heard. After Hannah was convicted, her attorney filed a motion asking for a new trial. The prosecution, specifically an assistant district attorney named Deborah Leslie, filed a briefing opposing that motion. She also prepared a proposed order for the judge to sign denying the motion. On September 12, 2025, the trial court issued that order that the judge signed. The Supreme Court's opinion described it as an order largely prepared by ADA Leslie. So here's the problem. ADA Leslie used artificial intelligence software to draft those documents. And the AI-generated fake case citations, they reference court decisions that don't even exist. And there are quotes that are attributed to real cases that those cases never really actually said. So she didn't independently verify any of them before filing this. That's an important distinction. Now, when this first came up at oral arguments on March 18th, the justices identified 9 problematic citations in the trial court's order, You think that was bad enough, but the full picture is even worse, as we find out today. After the hearing, ADA Leslie filed a sworn affidavit. That's a statement made under oath in which she identified 12 additional cases in her briefing before the trial court that were AI generated and unverified. On top of that, she withdrew reliance on 9 more authorities from the state's appellate brief before the Supreme Court itself. And the court independently found at least one more case that Leslie missed in her own accounting. So in the appellate brief, they were all contaminated with either fabricated or misattributed legal authority. So this wasn't just a couple of typos. This was systemic. And this young girl is sitting in prison for the rest of her life. There's one more thing that the opinion revealed. When ADA Leslie was confronted about this at oral arguments, her initial response was a bit misleading. She told the justices that the citations were not in the version of the order that she submitted to the trial court. She said, and I'm reading from the opinion here, "I did prepare an order. That order was revised." The implication was that someone else introduced those errors. But the court pointed out in a footnote that those same non-existent cases appeared in Leslie's own original brief opposing the motion for new trial. They were there from the start. The AI generated them, Leslie filed them, and the trial court adopted them into the order. That's the problem. Justice Land, who wrote the majority opinion, said the court has no rule against the responsible use of artificial intelligence software by attorneys. He's not saying AI is banned. He's saying the obligation to verify your work is yours as the lawyer, and that the obligation was violated here. And that's that they expect from Georgia lawyers. So in resort did 4 things in response. First, they admonished, which is a formal public reprimand. They did that for both ADA Leslie and the Clayton County District Attorney's Office. Not just the individual lawyer, the entire office. Second, they suspended ADA Leslie's privilege to practice law before the Georgia Supreme Court for 6 months. And third, they required her to complete 12 hours of additional continuing legal education, specifically in ethics, in brief writing, and the proper use of artificial intelligence in the legal system. And she has to demonstrate compliance before she can be reinstated. Fourth, and this one is very important, the court ordered the state to produce all communications between the district attorney's office and the trial court concerning the proposed order. That includes any letter, email, or apology the DA's office may have sent to the trial judge about the problems with the order. Now you ask, why does that matter? Because the court wants to know what happened behind the scenes. Did the DA's office try to contact the judge about the errors? Did they send an apology to the trial court? Whatever was communicated, Andrew Fleischman, Hannah's attorney, now gets to see that too. Full transparency. It's only fair. Now, there's a partial dissent worth mentioning here. Justice LaGrua agreed with sanctioning ADA Leslie, but disagreed with admonishing District Attorney Tasha Mosley's office. Her reasoning was that a district attorney has to be able to trust the people who work for her. She wrote that every assistant district attorney takes an oath to do their job ethically and professionally, and she found that the DA's response, which included a letter apologizing to the court and outlining internal sanctions against Leslie, to be sufficient. Justice Colvin joined in that partial dissent, but the majority disagreed. And they made an interesting point in a footnote. They noted that Justice LaGrua referred to Mosley as the elected district attorney, and the majority responded that all district attorneys in Georgia are elected, and that status has no bearing on their obligations to the court or the court's obligations when faced with misconduct from their offices. In other words, being elected doesn't create a shield. The opinion also makes clear that these sanctions are specific to this case and don't prevent the State Bar of Georgia or the Judicial Qualifications Commission, known as the JQC, from pursuing their own proceedings if they choose to. They're not out of hot water yet. So we move on to section 3. Is this a win for Hannah? This is the question everybody watching this video wants answered, I'm sure. and I'm going to be straight with you. The ruling is not a reversal of Hannah's conviction. It never was supposed to be. This is not a new trial. It's not an acquittal, and nobody is going home today because of this ruling. What it is, it's a reset. It's a very important reset. The court erased the old order that denied Hannah a new trial and sent the case back to the trial court to do it over, correctly this time. And the court specifically said that's not deciding on the merits of Hannah's appeal. They're not ruling out whether her trial lawyer was ineffective. They are not ruling on whether the missing jury instructions mattered. They are saying we cannot evaluate those arguments when the order we're reviewing is built on fabricated legal authority. But here's the part that matters. The old order denying Hannah's motion no longer exists. Whatever legal reasoning supported that denial, including the citations to cases that were made up by artificial intelligence, that's all gone. It's vanished overnight. The trial court judge now has to write the order herself. Let me say that again. The trial court judge now has to write the new order herself without relying on work product from either side. And she has to do it knowing that the Supreme Court is watching, that the state's credibility has been damaged, and that the entire record of post-conviction proceedings is contaminated. So is this favorable for Hannah? I think the honest answer is it's more favorable than where she was yesterday. Yesterday, there was a standing order denying her a new trial. Today, that order doesn't even exist. The door that was closed is definitely now open. But I also need to tell you what could still happen. The trial court could issue a new clean order denying the motion again based on real case law this time. That's absolutely a possibility. And if that happens, Hannah's team could appeal again. And the Supreme Court would then address the actual merits of that ineffective assistance of counsel claim that Mr. Fleischman made before the Supreme Court on March 18th. So this isn't a guarantee of anything. It's an opportunity, though. And the reason it matters is that the opportunity exists only because the Supreme Court took the integrity of the process seriously enough to say, this isn't good enough, start over. So what happens next? Well, here's the roadmap. The case goes back to Clayton County Superior Court. The trial court judge has to prepare and issue a new order on Hannah's motion for a new trial. The Supreme Court was explicit. That order cannot be written by either the prosecution or the defense. The judge does it herself. That's a direct response to the fact that the original order was, in the court's words, largely prepared by ADA Leslie. Step 2, the new order will either grant or deny the motion for a new trial. And if it grants the motion, Hannah gets a new trial. If it denies the motion, Hannah's team appeals again to the Supreme Court. Step 3, if the case comes back to the Supreme Court, the justices will finally address the merits, the actual questions about whether Hannah's trial lawyer was ineffective and whether those missing jury instructions would have changed the outcome. Those questions have never been answered. They're still waiting in the wings, so it's kind of like an ace up the sleeve at this point. There is no announced timeline for the trial court's new order. These things can take weeks to months. The judge herself has to do all of the research, prepare the order, and it has to be dead, solid, perfect because the Supreme Court is watching. One thing the court said I think everybody should hear. They wrote that they strongly encourage trial courts to carefully review proposed orders with the understanding that artificial intelligence software, with all of its potential risks and benefits, may have been used to prepare such proposed orders. That's the Georgia Supreme Court putting every trial court in the state on notice. If a lawyer hands you a proposed order, you need to verify it, judge, because this is what happens when nobody does. Before I close, I want to share some observations about what this ruling creates going forward. And I need to say something very clearly first. What I'm about to share are not predictions. They're interpretations based on 29 years of watching how the system operates under pressure. I'm not an attorney. I'm not telling you what will happen. I'm telling you what the conditions look like and what doors are now open that maybe weren't open before. So first, the trial court judge. The Supreme Court told Judge Jules Scott to write this order herself. That's not a standard practice. In Georgia, it's common and accepted for the winning side to submit a proposed order that the judge reviews and signs. And the Supreme Court knows this. They're not just prohibiting the practice in this case. They're doing it because the last time it happened, the order that came out of the courtroom was built on fabricated authority. Think about what the judge is now facing. She signed an order that was largely prepared by the prosecution, and that order contained fake citations. Whether she knew they were fake is a separate question, but the Supreme Court just told every trial court in Georgia to verify proposed orders because AI may have been used to write them. The instruction applies to every judge in the state, but Judge Scott is the one who has to write this particular order from scratch, knowing the Supreme Court is going to read every word of it. And on top of that, the court ordered the state to hand over all communications between the DA's office and the trial court about the original proposed order. Whatever was said between those offices, Andrew Fleischman, Hannah's attorney, now gets to see it. That's a transparency measure. It should tell you that the court is not just looking at the documents, they are definitely looking at the process of this case. Second, the state's position. The district attorney's office has taken institutional damage here. They can't avoid it. They were publicly admonished by the highest court in the state. Their ADA was suspended from even appearing before the Supreme Court for a period of 6 months, and she has to be retrained on certain things. The appellate brief they filed, which is supposed to be the state's best argument for keeping the conviction intact, had 9 authorities withdrawn because they were unreliable. The entire post-conviction record has been called into question. And if the trial court denies the motion for the new trial again, the case goes right back to the Supreme Court on the same ineffective assistance of counsel arguments. This time, the justices aren't going to be sidetracked by the citation issue. They'll actually rule on the merits based on the questions they asked at oral arguments in March, particularly around whether the missing jury instructions would have changed the outcome. There is genuine uncertainty about how that goes. So the state has to calculate, do we go back to the Supreme Court on the merits with damaged credibility, or is there a different path? Now, I'm not saying that they're going to change course. I'm saying the pressure to consider it is real in a way that it wasn't before. Third, Hannah's appeal going forward. The ineffective assistance of counsel claim that Andrew Fleischman built, the one about the missing jury instructions on the citizen's arrest and the defense of others, that's still alive and well. It's never been ruled on by the Supreme Court. That's the question. That's what's been waiting in the wings behind all of this. So if the trial court denies the motion again and the case goes back up, Fleischman now has additional context. The original proceedings were contaminated. The communications between the DA's office and the trial court are now being disclosed, and the state's credibility has been publicly damaged by the court itself. None of that changes the legal standard for ineffective assistance of counsel, but it's the reality of the landscape the case now sits in. And the opinion preserves the possibility that the State Bar of Georgia and the Judicial Qualifications Commission could take their own independent action against ADA Leslie. If that happens, it becomes part of the public record that Fleischman can reference. So where does this leave us? The merits of Hannah's appeal have not been decided, but the conditions around the decision have definitely changed. There's a new door that's open. The system that kept it closed has been told by the highest court in the state to start over and do it again. I want to say this directly to everybody that's watching this video. Nothing about what happened today changes what happened on May 7th, 2019. Mr. Herring lost his life. Hannah is in prison. Both families are living with the consequences of that day every single day. What happened today is about the system. It's about whether the process that led to the denial of Hannah's motion for a new trial was built on a reliable foundation. And the Supreme Court looked at it and said it wasn't. Not because of the arguments themselves, but because the legal citations supporting those arguments were fabricated by artificial intelligence and nobody verified them. The court took that seriously. I think that matters. I think both families deserve to know what happened and what it means, explained without spin, without sensationalism, and without agenda. We're going to stay on this case. John and I have been covering Hannah Payne since the beginning, and we'll be here when the court issues its new order. I'm Andrew Baxter, known on social media as Drew Breasy. This is the Comm Center, and every good true crime story starts with a 911 call.